Hey everyone. Good morning. Say, just kidding. Good afternoon. Happy Friday. I interrupt your evening for a quick moment, if you will, if you don't mind. We've had I've had a very rough week, interesting week. Fridays usually suck for me, but we'll find out. I wonder if the news is good or bad. My curiosity is riding like a small kitten into play. Thank you, Clue, for the redirect. I will send you all right back over to Clues. I'm sorry to interrupt. Praying for good news. They're coming on in. Grab a seat, grab a seat. If you're coming from the cooters, keep your legs closed. Don't fly your planes into our buildings. Hey, living life. I do appreciate that. I've been taking medicine and all the things they recommended, so but I don't have much time, so we'll just jump right into it. Uh as I've mentioned before, there are legal accountabilities for sending people cease and desist, right? There is I've had this itching feeling for months now that I was going to be hit one by one with litigation in each plaintiff's collective states, so long as they lived in a different state, and that I would be forced to then retain attorneys like I had to do in Oklahoma, like I'm having to do in Oklahoma, and like I would have to do if Brittany went through with her threat. Now, on the other hand, I also knew that Brittany's threat also came with the idea that she may be, as the video we played earlier stated, gunning for our channels. Neither of which I was okay with allowing to happen. So I filed what is called a declaratory judgment against Brittany, which now forces jurisdiction to be Pennsylvania, not North Carolina, and Brittany is going to have to answer for what she wrote on her C&D. Because in my opinion, what she wrote on her C&D was not truthful. I feel like it was a matter of freedom of speech. Living life. Welcome back. Thank you. And I'm tired of these people thinking they can shove lawfare down my throat and we won't fight back. So we fought back. So right now, what we filed again is a notice to defend, and it is a declaratory judgment under 42 PA. Defendant Jessica and Brittany, you've officially been actually served. You see how attorneys do it? Service, actual service. Process server, knock at the door service. But I'm going to try to be professional about this because this is serious, right? This is a serious thing. Defendant Jessica, by and through her attorney, hereby files this instant action for declaratory judgment against Brittany Nicole Jackson concerning the allegations made in a cease and desist letter dated September 10th. I am an adult individual. Brittany is an adult individual where we reside. This court has jurisdiction pursuant to 42 PA because this action seeks a declaration of rights and legal relations under Pennsylvania law. Venue is proper because the relevant events giving rise to this action occurred within this jurisdiction. Ms. Sang operates a YouTube channel known as Granny's Watching, wherein she engages in lawful commentary on matters of public concern, often commenting on true crime matters. BNG, Brittany Nicole Jackson, operates two YouTube channels, one claiming to offer commentary on matters of public concern, supposedly focusing on true crime, and the other, her drama channel. I'm on the other page, so I don't see the comments or anything, but do it, lady. Thank you, Full Deck, for the gifted membership. Purple Haze, thank you for becoming a member. Yeah, this is, listen, I'm tired of being threatened with legal action. Thank you, Candy. I appreciate you recognizing that. You know what? You're not wrong. Once again, you're being forced to stand up for yourself in court. Thank you. I'm not even, do I want to do this? No. Do I want to sit back and possibly have my income taken from me via this channel or via more frivolous litigation in different courtrooms? Nope. Thank you, Clue. Thank you, Megan. 36 months. Such a blessing to have all of you, honestly. 14 months. Miss Sang on her YouTube channel, Granny's Watching, in 2024 discussed the disappearance of Sebastian Rogers, a missing teenager from Tennessee. Miss Sang's supposed opinions on the missing teenager clash drew the ear of certain individuals involved in the missing teenager matter, mostly YouTube content creators, including the teenager's father and the public figure Dog the Bounty Hunter, legally known as Dwayne Chapman. These individuals banded together and brought suit against Miss Sang and Stephanie Barbecue, making outrageous accusations that they were operating a RICO organization with the goal to hinder the search of the missing child. Brittany joined the RICO lawsuit against Miss Sang and Barbecue, with 9 other plaintiffs filed in this court on October 18, 2024, alleging many similar claims set forth in her cease and desist. Notably, on or about September 18th, I was in receipt of a cease and desist letter dated September 10th from Rancher Harris. Letter, although now pro-offering new allegations. Make no mistake, BNG's involvement in At Night Media was based on her own personal vendetta against me. The plaintiffs thereto formed a symbiotic relationship with BNG. BNG was used to confer jurisdiction for their lawsuit in this court by including Ms. Sang for the convenience of their chosen counsel. And 2, BNG was given, by her own words, free counsel to pursue baseless claims against Ms. Sang, even where the statute of limitations had expired. See, when I called you a fat, wasteful piece of shit, it was well beyond the legal time frame for defamation. Thank you, Kim. Thank you guys so much. I will come back over to you all, I promise. Listen, somebody has to hold somebody accountable. I don't know about all of you, but I'm not bowing down no more and being fucked over. So I'm just, excuse the crass statement there, but that's how I feel. And At Night, first Jessica, the plaintiff sought an injunction with an accompanying civil action complaint against myself and Barbecue. So this is just going to be the breakdown of what happened in PA, all right? The claims by the abusers, the litigants, their counsel of record, and just a name counsel of this court system in this process were thoroughly rebuked by the Honorable Kelly D. Eckel via her order dated April 17th. 2 days later, she filed a response. All right. This is going to break down on Pennsylvania, and although it's interesting, I'm sure none of you want to go over it again. Plus, we're on a time frame. I really interrupted Clue. This is how bad they did in PA. This was strategically done without just cause to preclude and therefore prejudice myself and Barbecue. Since January 12, 2025 fell on a weekend under computational rules, a response filed by January 13th would have been timely, but they weren't timely. All right, Judge Eckel heard argument on the aforesaid date, therefore held the matter under advisement. He has to give a whole breakdown so the judge understands how we got here. We were granted our motions to dismiss, only awarded attorney fees, but did not preclude the ability to seek an award of punitive damages. Since Judge Eckel did not preclude award of punitive damages, I filed a motion for punitive damages on May 3rd. Should be noted thereafter, the plaintiffs, including Brittany, filed an appeal to the Pennsylvania Superior Court. The appeal was dismissed as plaintiffs failed to follow the appellate rules of procedure, much like the incompetent complaint and injunction they filed against me. Amazingly, after seeking the reinstatement of the appeal with meritless and utterly bogus reasoning, the Pennsylvania Superior Court, per curiam, reinstated the appeal there too. Currently, I await jurisdiction be returned to Judge Eckel for a determination of attorney fees yet to be filed and her previously filed request for punitive. Here's Brittany's cease and desist. Publication of confidential domestic abuse on or about July 18th or live streams on your channel. You displayed and discussed a confidential domestic violence report involving Ms. Jackson without her consent. Remember, this is their claims against me. This is what they wrote. Holy shit, Julia. Thank you for the 10 gifted. Coming in hot. Thank you. I will come back to everybody's things, I promise. In communication with another creator, racking you all for 50 via Cash App for exchange of this report. You state, I didn't realize it was a beatdown. We know all this. It will be shown herein that this statement pro-offered by S. Rancher Harris, Esquire, was an attempt to bully and cow Miss Sang, as said statement has no legal basis. You know which one has no legal basis? This one. North Carolina law recognizes public disclosure of private facts and intrusion upon seclusion as actionable torts. By unlawfully exposing Ms. Jackson's personal, sensitive, particularly concerning domestic violence or children, you have committed a serious invasion of her privacy. Would you all be shocked to find out that it's not a legal tort in North Carolina? That's not a legal tort. Barry Bullfrog, welcome. I hope you're a friendly bullfrog. We haven't had good experience with frogs. I saw somebody else became a member. I'm sorry. Branson, thank you. Welcome. Granny, would your PA? I don't think he can. Pro hack vice in Oklahoma. I don't know if that's a possibility. I'm sure if it were, he would have offered. He knows this case like the back of his hand at this point. He's very much aware of everything going on. 1 second, please. Saying so, Beach. Yeah, that was, to put simply, a lie. And as my attorney wrote, that statement pro offer by S. Rancher Harris, Esquire, was an attempt to bully and cow myself, as said statement has no legal basis. Brittany answered. Thank you for answering the door, by the way. Pro hoc vici? That's an interesting word. Number 6. Let's read number 6. Number 6 would be this one. Threats and harassment of Miss Jackson's moderators. My attorney wrote, to think S. Rancher Harris, Esquire, believes that a cause of action could rest on claimed conduct toward unnamed individuals based on screen names is incredulous. It is clear Attorney Harris has no grasp of the YouTube world, wherein those claimed screen names could all be accounts of the same person and or ghost accounts and or YouTube accounts operated by Brittany or from those taking direction from Brittany. Disclosure of those individuals' identities welcomed, so thorough depositions can be scheduled via subpoena to this jurisdiction. You see that, moderators? Sasha, thank you so much. You hear? Are they hearing that loud and clear? You will be deposed and your identities will be revealed and you will be questioned by this attorney. That's what happens when you want to put your names on these legal filings. And you want to keep threatening people with frivolous litigation. So just so we're clear, that's what you opened up for yourselves. We got a good stare at that, right? Okay, moving on. Questions presented. The materials referenced in Brittany's cease and desist letter as confidential records were obtained lawfully through a Freedom of Information Act request and were not subject to any confidentiality order, protective order, or statutory restrictions on disclosure. The records discussed by myself are public by law, and any publication is protected speech under the First Amendment. Contrary to BNG and her not learned counsel, North Carolina does not recognize public disclosure of private facts as an actionable tort. Go down to the footnote of 7. Amazingly, Brittany has again hit the legal jackpot with a second attorney that postulates mischaracterizations of law. Oh, I can't laugh because my throat. Ooh, amazingly, Brittany once again hit the legal jackpot with a second attorney that postulates mischaracterizations of law. Oh, shit, I just love a good little snappy. Ooh, you gotta love a Philly attitude, don't you? That's actually hysterical. Oh, man, hit that thumbs up if you have it. All right, let's go back up. All right. If Brittany had a claim, which she does not, the onus of responsibility for disclosure rests at the public department that released the information under the FOIA or the actual requesting party, to which I am neither. In Pennsylvania, the elements of publication of private facts are 1, publicity given to, 2, private facts, 3, which would be highly offensive to a reasonable person, and 4, is not of legitimate concern to public. Pennsylvania law does not impose liability for publication of factually accurate information that is newsworthy or of legitimate public concern. The entity disclosing the information via a FOIA request makes it clear the report was a matter of public record and not actionable under Pennsylvania law. This claim, as asserted, is not actionable under North Carolina law either, as this state does not even recognize a legal claim. Doesn't even recognize it as a legal claim. Oh, shit. Thank you, Rebel Soul. Okie softball girl, welcome. Just know we all support you. Thank you, Kathy. Kai K, welcome. Thank you for becoming a member. Gamers Cruising, way to go, Granny. Thank you. You're one strong woman. I admire you. Huh, I might just be an idiot for all I know. Sasha, thank you so much for the 10 gifted. And Jill, as always, thank you. My attorney wrote it. My PA attorney. Be nice, try it. Thank you. We'll just have to do the chef's kiss in a minute. Therefore, if North Carolina law is applicable to the analysts here too, BJ claims fail as a matter of law. However, the North Carolina Supreme Court has suggested a plaintiff might be able to bring an intentional infliction of emotional stress claim under some circumstances involving the publication of embarrassing private facts. Upon all information and belief, the discussion concerning this incident fails under an intentional infliction claim as well. In North Carolina, a civil claim for intentional infliction allows a person to seek compensation for severe psychological injury. This claim applies when someone's deliberate and shocking behavior causes harm without physical injury. To make out a claim for IIED in North Carolina, one must engage in extreme and outrageous conduct, engage in conduct intended to cause severe emotional distress to another person, or 3, engage in conduct that in fact causes severe emotional stress to another. Severe emotional stress means any type of severe and disabling emotional or mental condition, such as neurosis, psychosis, chronic depression, phobia, trained professionals, generally recognized and diagnosed by trained professionals. Note, mere temporary fright or anxiety, disappointment, or regret is not severe emotional stress. A brief pursual of Brittany's YouTube channel indicates she has not suffered from severe emotional stress as a result of this claimed incident. One quick look. All right. Moreover, BJ, who claims to be traumatized, fails to produce any diagnosis by a trained medical professional of such condition. Furthermore, BJ continues to discuss me on a near daily basis, even after sending out her cease and desist letter, which counters any claim she suffers from severe emotional stress. To think one is so traumatized but continues to offer her own near daily commentary on myself evidences the falsity of her claims, while also showing by her own actions her ability to function has not been impaired. Based on the above, BJ fails to be able to make out the elements to form a basis to assert she has suffered IIED. Attempts to prove her claims of IIED are, to the contrary, actionable against BJ for abuse of process. Barbara, thank you. I prayed this morning she would need documentation. She sure would. Amma, thank you so much. Be proud of how strong you are. I'm only strong as you guys are. Stay strong. Don't let them for pushing you around. Thank you, Barbara. I'm tired of being pushed around. Listen, this was a threat to take my livelihood. Okay? We all heard it. We all saw it. What was I going to sit back? Were you supposed to sit back and allow that to happen? Now, I can present this to Team YouTube and show, what this woman's been trying to do and how she's threatening. I mean, do we have to, quickly derail?
Yeah, let me see.
You're scared. We know you're scared.
Hold on.
This time, good for everybody to report them.
Just leave me alone. Y'all go your way, and I'll go mine.
Now. It's too late.
Oh yeah, I know.
Oh, it's too late now, right?
If members only is not showing up.
It's time for a strike. You want to strike? It's time for some strikes.
Time for some strikes. Remember all these?
Harassing them and freaking.
Remember this part?
You ain't got that YouTube money, honey.
What are you gonna do when you don't got that YouTube money, honey? You ain't taking mine. All right, back to what I was reading. I do apologize. I just want to remind everybody why I felt how I was feeling and why I felt this was important to address. Upon all information and belief, BJ is considered a limited purpose public figure by operating a YouTube channel, voluntarily thrusting herself to public controversy by joining as a plaintiff in litigation related to the highly publicized case of a missing teenager, and by accusing multiple YouTube creators of operating a RICO. BJ's claims against myself in this underlying matter were rebuked in toto by Judge Eckel. Judge Eckel held BJ is, at minimum, a limited public figure. As a result, any public commentary on BJ's actions and statements, as alleged above, are constitutionally protected speech. Moreover, the allegation that myself is responsible for others discussing BJ is false and lacks any actionable merit. Make no mistake, BJ's public actions and controversies are what draws her public attention, especially since she interjects her life into the public sphere. Is this really you? Is this really you?
Yeah, it's me.
Okay. I had a troll backstage for a while.
No, it's me.
What you think, girl?
I was, look, so I'm live and fiance's like, he was trying to whisper. He's like, Granny's going on. And I'm
I
like,
didn't know you were live. I'm sorry.
no, you're good. I was like, what? I couldn't hear him. He's like, Granny's going on. And I'm like, oh, okay, what? And so he shows me the laptop or the tablet. And I'm like, oh, I got you. I was like, well, let's do a redirect, shall we? And by then I saw your text message.
Yeah, thank you so much. Thank you.
Hey, I have a
Hey, B Tim.
what's up? I have a question. So is this basically like, so if she does bring a lawsuit, it's forced to be in PA or something like that?
No, this is solely a legal determination that what they put in those letters is not actionable. So she has to come to PA and prove, or, go before a judge and argue that what she threatened me with is actually actionable.
Right. So it's almost like you sent me the C&D. Now you need to come here and prove that it's actually legit.
Right.
And she's got to have to hire an attorney in PA to fight this. To
She may.
basically, I mean, or she could go herself, but she can't use her North Carolina attorney because he's not barred there, right?
Right. Unless he somehow finds a way, but it definitely brings jurisdiction back to PA. Yeah.
Mm-hmm.
Okay, so basically, how long does she have to answer this till?
I think maybe 30 days, but I'm not sure. Usually if they're being served, you have 30 days. I'm just guessing here.
Okay, so
Yeah.
and if she doesn't show up and she doesn't fight this and this goes through, right?
Then I get the judgment on my behalf, which you'll see when we get down further what I'm requesting with the judgment.
Oh, okay. All right. Yeah, I've never heard of this before. I'm not a lawyer.
It's interesting, isn't it?
Yeah, I mean, I don't know. I mean, I've never heard of it before, so I'm learning. I don't know nothing about this situation, to be honest with you. So I'm kind of interested about this because, a lot of people were sent those cease and desist. So just
Yeah, we didn't know about it either. But fiance is, when I tell y'all he's super smart, yeah, he's got a high IQ. So he did some research and found this thing called a declaratory judgment.
Mm-hmm.
Okay.
And that's what this is.
That's exactly what this is.
Now,
thank you, Cletus, for being so smart.
Could this bite you in the butt or anything? Like what?
I don't think so.
Okay. I mean, I never heard.
I mean, the only way it could is the only thing that could come of it is they can say, no, it is actionable, and then she can pursue action against me.
Right. But it would have to be in like Pennsylvania then. Right.
That I don't know.
That I don't know either.
Okay. All right. Thank you. I just want to ask those questions.
Yeah, I appreciate you asking. And yes, she was served today.
You said she answered the door.
Yeah. She was served and answered. Yeah.
I mean, she was talking a lot of shit in the Lemon's head. Said, Big Tim is never right. He's an idiot. And everyone, but I'm just kind of laughing now because I'm like, oh, I guess I'm right. I guess you did. I guess I was right again. It's kind of like, Big Tim is always wrong. I'm like,
Big Tim, I got answers. So any litigation she wants to do would have to be here. We just reverse jurisdiction to PA. Jurisdiction is now PA. It will never be North Carolina. It's now PA, and she has 20 days to answer.
Oh, okay.
That's what I thought. I thought with the declaratory judgment, it moved it to the person who filed it.
It's kind of like a reverse Uno and a pick up 4 while you're at it, right? Anybody else play Uno? Great game.
No, it is.
That's essentially what it is. So, and I agree, WSN. Thank you. Yeah.
I mean, I feel like I go on YouTube and I learn more and more about lawsuits every day.
I know. More than we ever wanted to know, don't you think?
Right.
It's like, man, I should have just went to law school. What I did, I was too broke as a kid to do that, unfortunately. So couldn't afford law school, unfortunately. But you can continue. I'm sorry.
Okay, so it just basically says, upon all information and belief, the actions of BJ threaten and continued litigation despite being determined to be a limited purpose public figure is a clear attempt to not only mitigate the damage she faces in the underlying action referenced herein, but also an attempt to take another bite at the apple at chilling my free speech based on her feelings that have already been rejected by this court. To be clear, it is BJ who has repeatedly engaged in conduct believed to be harassing, defamatory, and retaliatory. For example, BJ continues to offer false medical information about Miss Sang, which is defamation per se. BJ is engulfed in by what she claims to, what is this word? Abhor drama because it makes her money. Pure and simple, drama sells.
I didn't see it. I'm sorry.
ABHOR.
Yeah, bore.
Yeah, like she claims to dislike it so much, but yet she's so engulfed in it. Despite sending the cease and desist letter, BJ continues to poke and prod by consistently making public statements about myself. Rules for thee, but not for me is the modus operandi of BJ.
Is that in there?
That's
Yeah.
what it
Hold
says
on.
right here. Yeah. 71. It says it. Because I mean,
I see it.
it doesn't take a
freaking
rocket
hilarious.
scientist to figure out. You know, Brittany, when you say your attorney's watching, you can tell mine really was.
Mm.
The statements referenced in the cease desist letter are not defamatory, false, or malicious. BJ joined in litigation and was found to be thoroughly meritless. Since the outcome was favorable to Miss Sang, she has even more basis to offer her opinion of the litigation. So, you know, they put in the cease and desist that I said her litigation is frivolous.
Yeah.
Yet some statement of fact can be so egregious that they will always be considered defamatory. Those statements are typically referred to as defamation per se. These type of statements are assumed to harm a plaintiff's reputation without further need to prove that harm. Statements that are defamatory per se where they falsely impute to the plaintiff one or more of the following things: a criminal offense, a loathsome disease, matters
Incompatible.
thank you, I don't know why I'm reading too fast, with business, trade, profession, or office, or serious sexual misconduct. The three statements asserted in a cease desist letter attributable to Ms. Sang fail to meet the above criteria of defamation. In North Carolina, per se defamation has a broad last category as opposed to the restatement of torts, which can consider certain statements that subjects one to ridicule, contempt, or disgrace as defamatory per se. The above even fails under North Carolina's broader standard. Public officials or all-purpose public figures and limited-purpose public figures must prove that the defendant acted with actual malice, knowing that the statements were false or recklessly disregarding their falsity. North Carolina courts recognize a number of privileges and defenses in the context of defamation actions, including substantial truth, the opinion and fair comment privileges, and the fair report. In North Carolina, the fair report privilege protects accurate reports of government proceedings and public records. Among other things, the privilege applies to court proceedings and information contained in court documents. It also extends to reports of arrests and the charges upon which the arrests were based. And then see L. Cone, First Jacksonville Daily News. Number 8, this law protects me from comments associated with the RICO litigation since the case had no merit. See Exhibit 2 attached here too. It also protects her comments about the public record concerning the domestic violence incident. Anybody else want to read? No, I'm getting tongue-tied. Oh, B. Tim jumped down. Okay. As a result, BJ's claims...
Where are you at? I can do it. I'm sorry.
Okay.
Where are you?
82.
As a result, B&J's claims hereto fail based on recognized privileges under North Carolina law. C. Cyber harassment did not occur nor civilly applies. 83. The allegations made by B&J against Ms. Singh do not constitute a violation of North Carolina General Statute 14-196.3. 84. Notably, North Carolina General Statute 14-196.3E provides the following. This section does not apply to any peaceable, nonviolent, or non-threatening activity intended to express political views or to provide lawful information to others. This section shall not be construed to impair any constitutionally protected activity, including speech, protest, or assembly.
That dang free speech.
It gets them every time.
Mm.
85. It is quite clear the statements referenced as cyber stalking and harassment were non-threatening. 86. Additionally, the comments referenced as attributable to Ms. Singh in this regard included constitutionally protected speech wherein lawful opinion of B&J, a limited public figure, was set forth. Dang, that public figure thing too.
I know, it keeps getting them.
87. Consequently, B&J's claims hereto fail to be actionable on their face. 88. Furthermore, B&J's claims fail because a criminal statute does not provide a vehicle for civil relief.
Let's go to the footnote. They're always fun. It says,
Oh,
there you
go ahead.
Go ahead. No, you go ahead. You sound better than me. I'm too present.
You're worked up.
Yeah.
It is obvious B&J has not learned from her RICO complaint filed in this court that criminal statutes are not viable as civil causes of action.
Damn.
I like this attorney guy.
I know. I'm telling you. I do too.
D. Statements concerning abuse are not actionable. 89.
Oh, where I minimized her abuse. That's not an
Yeah.
action, it's an opinion.
Is that what that's in regard to?
Yeah, 88 went to this footnote.
Mm.
Yeah. Because they quoted criminal statute and the C&D.
Right.
And like
Yeah.
you're saying, you don't get civil relief from a criminal statute.
I like that 89, this statement
Mm-hmm.
that she allegedly minimized abuse is not actionable.
Yeah, what the fuck's that even mean?
You want to go?
Sure.
Yay.
90.
You got to move this out of my
My
line of
arm.
sight. There we go. The statement of Miss Singh concerning this incident is a matter of her opinion. Consequently, disagreeing with an opinion is not actionable. 91. Further, the statement concerning this incident is not reckless, malicious, nor designed to subject B&J to public hatred, contempt, and ridicule. 92. In fact, the fair reporting privilege is a defense to the comments made by Miss Singh. See Lacombe versus Jacksonville Daily News. Consequently, B&J's cease and desist letter fails to offer a cognizable claim of any legally recognized action that can be brought against Ms. Singh based on opinion and fair reporting. E. Threats and harassment of Brittany Nicole Jackson's moderators. The allegations here too are nothing more than bald allegations. As a result, these allegations lack all merit. Moreover, B&J has no standing to assert the legal rights of others.
Oh.
A party file. I mean, that's wow.
Mm-hmm.
A party filing suit in Pennsylvania court must establish as a threshold matter that he has standing to maintain the action. Unlike the federal courts, which derive their standing requirements from Article 3 of the United States Constitution, standing for Pennsylvania litigants has been created judicially. Pennsylvania has two avenues for a party to establish standing. One, by statute, which expressly prescribes the individuals who have standing to pursue a particular action thereunder, or two, in the absence of such a statutory prescription, by satisfying the requirements of Pennsylvania's traditional standing doctrine. See Milby versus Pote.
Oh, that's weird.
These traditional standing requirements apply only when a specific statutory provision for standing is lacking. 99. Article 3 standing requires a concrete injury even in the context of a statutory violation. Spokio Incorporated versus Robbins. Since there is no statutory authority upon which B&J can assert the rights of others, traditional notions of standing would apply. Pennsylvania Supreme Court has set forth on standing requirements the following. The core concept of standing is that the litigant must be adversely affected in some way. Under this court's precedent, the prerequisites to standing are satisfied where the complaining party's interest is substantial, direct, and immediate, meaning that the party's interest surpasses that of the general public in procuring obedience to the law. The harm alleged was caused by the matter complained of, and the harm is not remote and speculative. Trust under will of Ashton. Okay, number 102. Here, there is no nexus between what B&J asserts is being done to others and some unidentified injury to her. Without a doubt, B&J's claims are remote and speculative. For judicial intervention to be triggered, there must be an actual controversy that is real and concrete rather than abstract. The allegations of B&J are not only false, but are clearly abstract while not setting forth any concrete injury. In North Carolina, standing refers to the ability of a party to demonstrate to the court sufficient connection to and harm from the law or action challenged to support that party's participation in the case. In North Carolina, a plaintiff can maintain an action for infringement of a common law interest, irrespective of any actual injury that may occur to her.
It's a lot, isn't it?
30 pages.
Jesus. All right, I'm going to skip to 107. However, if there was harassment of others, such as not protected by a North Carolina civil statute, the statute alleged to be violated hereto by B&J is criminal in nature, upon which an exception for peaceable, nonviolent, or non-threatening activity intend to express political views or to provide lawful information to others. It's that civil versus criminal thing that gets them. Yeah, go ahead.
In addition, there's also a provision in North Carolina stating that the law may not be construed to impair any constitutionally protected activity, including speech, protest, or assembly. Accordingly, B&J's claims hereto are attenuated as to how she is harmed and fails to set forth a
Modicum.
of evidence to show she has standing to make such claims in this regard.
Basically,
Oh.
she don't have any claims.
Yeah. Cause of action, declaratory relief. Ms. Singh incorporates by reference the above, so referenced as set forth at length herein. In the matter at hand, an actual and justicable controversy exists between Ms. Singh and B&J regarding the legal rights to free speech, fair comment on matters of public opinion, and whether she can discuss content about B&J's public actions.
Oh.
You go on, girl.
Ms. Sang contends she is entitled to a judicial declaration that A, her publications and statements regarding BNG are protected speech under the First Amendment of the United States Constitution and applicable Pennsylvania law or an alternative North Carolina law. B, her statements as alleged are not defamatory as a matter of law. C, her public discussion of, at a minimum, a limited public figure does not constitute harassment, threats, or any unlawful activity as alleged. And D, BNG has no lawful basis to interfere with the operation of Ms. Sang's YouTube channel based on the allegations contained in her cease and desist letter. A declaratory judgment is necessary to resolve this ripe controversy and prevent further harassment, threats, or interference with Ms. Sang's business by attempting to silence her constitutionally protected speech rights. Where I respectfully request this honorable court declare that my free speech is alleged by Brittany, set forth in her September 10th, 2025 cease and desist letter, is protected by the First Amendment of the United States. Declare my comments referenced in her September 10th cease and desist letter did not constitute defamation, harassment, or unlawful threats. And C, enjoin Brittany Nicole Jackson from continuing to threaten baseless legal action or interfering with my business relationships based on the allegations set forth in her cease and desist letter. D, award me attorney fees and costs as permitted by law and grant other relief as the court deems just and proper. Respectfully, my attorney and myself. Here's my verification, and the rest is just all the whatchamacallits. What do they call them that they forgot to put in their filing? Exhibits.
Yeah.
Thank you so much, Billy.
Well,
and on a weekend too. Happy Friday, Beach. Do it, Granny.
I just want to say I'm proud of you for not just this, but for also giving her a reason to get some exercise today.
Why?
By answering the door.
Oh, you ass. I knew you were going to say so. After I said why, it's on to me. I'm like, oh, yeah, durr. Yeah. I mean, it is. Listen, we do have a freedom of speech, right? And we all know, I personally don't believe that she was going to do anything further than submit this to Team YouTube. And the only way I can protect myself is through this. And then if she goes forth, and now she has to go forth, so she has 20 days to respond, and jurisdiction is now PA. And if I recall, I'm coming in late, but one question: has your lawyer watched any of her videos? Yes, that's how he was able to reference that Brittany's, what is like moda? What do you call that? Her
Modus
thing is like,
operandi.
yeah, rules for me, but not for thee. Can you do the same to Tony? No, he can't. It's too late. But this was an option that was here, and she has 20 days to respond. Jurisdiction is Pennsylvania, and quite frankly, is something that, I mean, are we going to keep allowing her to threaten us? And how many months now has she used? Oh, I got a lawyer. You guys will be down soon. You heard the video by Craig. You'll lose your channels. What are you going to do without the YouTube money, honey, and all that shit? Well, she did open this door.
The thing I think that's great about something like this, right, an action like this, is you're not asking for anything except for what you're perceiving and your attorney is arguing is your constitutional right to be upheld and for any future litigation related to the threat to be stopped.
Mm-hmm.
And I think that's great, right? I personally see that as using the legal system for what it's for. Somebody is trying to fuck with you and you use the legal system to tell them to fucking stop.
Right.
That's just kind of the way I see it.
Because if not, what happens, right? Then she files, and now I need a North Carolina. Now I'm being sued in Oklahoma, North Carolina. What's next? Tennessee, Florida. You know what I mean?
Mm-hmm.
Like, there was no reason for any of this to get this far. But if I recall correctly, you warned months ago, Cletus, when the whole litigation thing started, that there was a judgment, a filing, a motion such as this, didn't you?
Mm-hmm.
I did.
Yeah. Because, I mean, there was always this possibility. See, these people think you can just silence people and threaten people into silence and, do whatever you want to try to strong arm people into what you want done. And I'm tired of being fucked over.
Yeah.
Well, I think it's the thing of instead of the find, everybody talks about fuck around, find out. This is sort of instead of find out, this is go fuck around on your own. Right. And leave me the fuck out of it. And I think it's a good thing.
Oh, was there actually a signature required for yours?
I don't know. It was a process server, and there is, obviously evidence that she was served, photos and stuff. So yeah, I mean, I don't know if a signature. I like this footnote number 7. Amazingly, B&G has again hit the legal jackpot with his second attorney that postulates mischaracterizations of law. I like that comment. And I like this one. About screen names and that the disclosure of those individuals' identities is welcome, so thorough depositions can be scheduled via subpoena to this jurisdiction.
Yeah, that's rough.
Ow.
That's a rough one there. Fuck.
Ouch.
I wonder if they knew that she named them in these C&Ds.
Well, apparently she was what I heard is that they were offered to be put in these C&Ds. So I don't know.
Well, I mean, one of them has spoke out and said that most of the money was raised by them. So
yeah, 7,000, I believe they said.
Yeah, they were clearly invested, right?
Yeah.
And they were stated to be on the phone call.
Well, she stated that they were on the phone call, and maybe some of them have.
Well, they've said it in the chat. We were on the phone.
Okay.
So.
Thank you, Lisa. Thank you, Diamonds. Yeah, they did say that, they were on the phones with every call, and they clearly knew what was happening. What I think, though, is that, here's the other thing, right? Because I would have taken the C&D and just taken it and maybe abided by it, but there wasn't really relief that could be sought that was reasonable. I'm not giving her money. She's going to owe me in PA, right? And then when I saw her in another comment section that day, and she made the statement of, come on, I didn't just pay I'm paraphrasing, I didn't just pay my attorney $8,000 for C&Ds. We knew they weren't going to abide by them. Duh, use your common sense pretty much. Basically saying she has something up her sleeve. Well, I'm at a point in my life where I'm going to protect me and mine before you even get a chance to present what was in your sleeve. And that's what I felt like we did here.
No, I agree with that.
Thank you, Malicious Intent. I don't know if it's worth congratulations, but it does definitely bring jurisdiction to Pennsylvania. we will find out if she has legal standing on what she wrote in the cease and desist. And hopefully we can stop all of this and we can all get back to what we want to be doing and stop wasting the court's time. The only people that win at the end of everything are attorneys, right? Why do we want to keep throwing money into this just to attack each other? Keep it on YouTube, or better yet, stop speaking on people if you can't keep it on YouTube. Like my attorney said in this, the rules for thee, not for me. No.
Yeah. No, I do agree with that.
So fair reporting, of course, he misquoted a non-tort law. The allegations are not only false, but they are clearly abstract.
What was that part about the quoting the non-tort law?
Oh, yeah. Let's go back up to that. That's where he said she hit the legal jackpot again.
It was in the footnote, wasn't it?
Yeah, it's one of these footnotes. It's up here. Okay, number 7. So look for footnote 7. Right here. Contrary to the claims of BNG and her not learned counsel, North Carolina does not recognize public disclosure of private facts as an actionable tort. And then he footnotes it with number 7 because he wrote not learned counsel. And he said, amazingly, BNG has again hit the legal jackpot with a second attorney that postulates mischaracterizations of law.
So in the event, let's say in the event she doesn't respond to this, right? How do you know how that goes? I mean, would that, because I would think hypothetically that would just sort of rule in your favor by default, and that would be the end of it.
Right. It'd be a default judgment, and I would be awarded what I requested.
Which was basically for it to go away, it just to be done.
And attorney fees.
Yeah.
Yeah.
Damn.
I feel like that would probably be the easiest way to just be done with it, as somebody said recently.
Yeah, I mean, that's all I want is it for it to be done. Yeah. So basically, I'm asking they declare my comments as did not constitute defamation, harassment, or unlawful threats, that they enjoin Brittany from continuing to threaten baseless legal action or interfere with my YouTube channel, and then D, award me attorney fees and grant any other relief as this court deems just and proper. I mean, I do think it's intimidating for her to constantly, or Craig to sit there and say, oh, y'all going to lose your channels. Fuck around and find out. Who wants to sit on, I don't know, any day now if my channel's going to go down. You know how that feels? I mean, they're like, fucking trying to strong arm us. And I did everything I could to not be on her list of C&Ds, but there I was, right? There I was. Maybe Tara. Yeah. I mean, essentially, that's your answer to her C&D. Yeah. And Craig made it very clear. He has tons of money and the ability to pay for a lawyer, and that lawyers are cheap. So remember that when she now tells you all that she has to retain attorneys. Thank you, Kathy. Yeah, I did do this before, knowing Tony's would carry on. So it kind of sucks. Just like Clue, your attorney has perfected the art of I can't even say. Each can tell someone to go directly to hell in such a way the person looks forward to the trip. That's a compliment, Clue.
Yeah, it is.
Yeah. So this declares basically that Brittany's attorney lied about what was an actionable tort, that Brittany has no basis to request anything on behalf of her moderators, that her moderators are now open to giving their legal names so they can be depositioned and subpoenaed to court. Once again, that Brittany's using criminal statutes to threaten civil action, and that her statements are not my statements were not defamatory and they're protected speech.
Which they are.
Right. So now we're asking a judge to basically confirm that. And Brittany, just get lost. Just leave me alone from here on out. You do not have emotional distress claims against me. I'm not defamed. I'm not doing anything to you. I just leave me alone. We can stop. It can all stop. Well, I don't know if it can stop now because you rolled the tracks in motion. Don't forget either. Brittany did this, not me. Thank you, Diamonds. Thank you, Shadow. So I hope that I apologize for the wait. I wasn't to say anything until she was served because we were worried that she may avoid service. She actually answered service tonight. And as soon as I got home, I was able to go live and tell you all. But that is pretty much all I have. And Clue so kindly interrupted her own live stream to send you all over. So I'm going to send you all back. Hold on 1 second. Okay, sorry about that. Are you ready again to go back live, Clue?
Yeah.
Okay, I'm going to redirect on over. Thank you guys so much for coming up. And thank you for reading. I really appreciate you guys.
No problem.
And Cletus, thank you for telling me that there are actions to be had when people threaten things like this. I listen when you speak, you and Clue, so I appreciate that too.
Well, I'm glad it actually was of some merit because I wasn't sure. It was just something that I found and I thought was worth looking into. So I'm glad it has got some traction and hopefully it'll put an end to the bullshit.
That's all I think we're all asking for, right? If like my attorney said, she claims to talk about true crime, but she's really doing a lot of drama. If you're going to be in this drama world, then be in it. But for fuck's sake, stop threatening to take people's livelihoods. Stop threatening to take people to court. Let's stop going to court altogether. I mean, haven't we all had enough of it? And you know, either be in this sector and do what you do, or don't. But you don't get to have it both ways.
Yeah. I agree with that.
Like as pointed out here, she continues to poke and prod. She continues to speak on us after sending these C&Ds. It's not the way.
I don't think she'll learn.
Thank you, I appreciate that. Well, she may have to now, Chloe. What do you think?
Probably.
Yeah, probably. It is what it is. And this isn't something I wanted to do, but I certainly want to protect my channel and myself from further frivolous litigation. So
yeah,
that's what
for
we do.
sure.
Thank you so much, Amma. All right, I'm going to send you back over to Clues. Thank
Bye,
you, guys.
y'all.
See you in a minute. Thank you guys for being here. If you haven't, please hit the thumbs up. Thank you guys so much. I didn't even get to read them all. Holy shit, they came in quick. Sarah Q, we love and stand with Granny. Full Deck, gifted a membership. Purple Haze, Clue, Megan, I read. The Real Kels, Do It Lady. Lisa, welcome. Lily Rose, welcome. Melissa B, Do It Lady. Sucks to Suck, Stormy. Clue, I didn't even see she gifted 10 memberships. Holy shit, sorry. B Tim, I guess BJ will have to use that $88K now to use for a lawyer now. She may, B Tim, she may. 13, my favorite number. Auburn, welcome back. Damn it, Donna, never give up, Granny. Thank you. Julia with the 10 gifted. Kim, I stand with Granny. Thank you. Jana with the Do It Lady. And look, a YouTube baby. Lala, what a perfect time for it. Narrative, so damn proud of you with the 42 months. 42 months. Holy shit, thank you. Irish Eyes says, so proud of you, Granny. Well done. Crime Chronicles says, coming in. Ha. Thank you. Julie, we love you, Granny. You're amazing. 36 months. Where else do you see this? 42 months, 36 months, 21 months with a Sasha. Thank you. Branson Girl, welcome back. Crimson with the 16. Barry Bullfrog. Kathy P says, just know we all support you. Thank you. Kai K, new member. Okie Softbelt Girl, new member. Rebel says you're one strong woman. Thank you. Gamer. Sasha with the 10 gifted. Jill with the 10 gifted. Stand by you. Thank you. Be nice, try it. Amma, thank you. Twice. Barbara, thank you. Chai. Miss Mad Dog, Choo Choo. YNC Granny, thank you. Cambry, the 10 months, I'm very proud. Thank you. ML, welcome back. Mama Michelle says, I do love a good Uno reverse, Granny. Your army of supporters clearly have your back and are cheering you on. Stay strong, keep your head up. Thank you. Danny, thank you. Ain't that what her Give, Send, Go is title? Cyberbullying harassment? It was a defense fund before. Billy Sunday on a weekend, too. Sam Brown, do it, lady. What a badass you are, Granny, and Mr. Attorney Man. Mr. Attorney Man. Much respect to your attorney. Appreciate him guiding you through this. She opened that door. Shocked AF. You've been properly served. That's how it's done. Thank you, big girl. Sam Brown. Moon Magic with the 4 months. Well done. Thank you. Britt B. Do it, Granny. Happy Friday. Diamonds. Thank you. Lisa, I did read yours. Thank you guys so much. I read the rest of them. No, I didn't. Jill with the 38 months. Love you too, Jill. Thank you. The Wanderer sub with 37 because we are solid MFers. That's the truth. Captain Lee with 24. Sios with the 16. WSC with the 8. Thank you guys so much. Love that your attorney watches channel. After she sent the C&D, I told him she was live about me that night and he tuned in so he could, because a lot of times there's a telephone game, right? I told you all before, there's times I went to him like, oh my God, blah, blah, blah. And he's like, so, you know, what we think is legal, actionable, and sometimes it just isn't. It's the way it is. So, yeah, he listened for himself. Thank you, Rainbow. 21 months. Thank you, Mr. Blue. Now it's time to go to law school. I wish. Anyway, I appreciate all of you. I so rudely interrupted Clue. Queen, I saw you in the chat. I'm going to reach out to you. Jay, thank you. And I'm going to send you back over to Clue. I appreciate her stopping her stream when she just went live to direct everybody over. It means a lot. So thank you guys again. Rebel Soul with the 16 months. Keep us updated. You know it, girl. Granny inspired Uno for game night. I love Uno. I really do. Thank you, Cracker Jacks, for asking. Birdie Girl with the 6 months. You got in one day what some didn't get in months. Yeah. I don't listen. I don't want to be in any of this. Okay. We don't ask to be in litigation, but they've proven already they have no problem lying on declarations and throwing people into litigation. So this is the way I had to protect myself from more insanely, stressful, trying to find an attorney, afford an attorney, all of that. And this was the only way I saw a way to prevent either A, more litigation, or B, losing my channel. So now I know, whatever this comes of this, I can present it to YouTube. My channel will be protected, and hopefully this can just stop. I just want it to stop. We put ourselves on a public stage. If you don't want public commentary, don't be on a public stage. People talk badly about me all day, every day too. I don't go, every time going live. Oh my God, I'm a victim. All that shit. You don't get to be a victim and also be the perp at the same time. The moment I was sued in Pennsylvania, my name should have never came out of her mouth again. And then to go forth and send me a C&D and continue to speak on me again and share out channels that are speaking on me, your motives are clear. And I think PA will see it again for what it is. So I'll see you in PA, Beach.